we can pay a co-broke, all right, which is probably the most common. The seller's agent's usually going to negotiate an entire fee. And then what he's going to do is share his fee with the buyer's agent. That's commonplace. That's usually how it happens. But the buyer's agent can also charge a retainer fee. They can charge a success fee. These are individual fees that are in the buyer's agency agreement that you take a look at. Maybe your company does that. It's all there. That's all fine. Remember I said you had to be an active broker to collect a commission before, right? Well, let's say that you get into contract on let's say May 30th. And then you don't pay your you don't want to be expired, all right? You want to be inactive. So let's say you do your continuing education, or you don't do your continuing education, you forget that, and you pay your fee at the end of June. You have to pay by June 30th, all right? We'll talk about that in Appendix A in detail. That puts you on inactive status because you did not, that you didn't do your continuing ed. So until you do your continuing education, you can't do anything, can't sell real estate. But because you got into a deal in May when you were an active agent, you can still collect the commission from that deal, right? Even though you're inactive now, you can still get your commission. You don't lose your commission. If you were inactive when you did it, you will not collect any commission. Once you become inactive or you become expired, you have to stop all of your brokerage activities, all of it. We'll get into a big bunch of detail when we start Appendix A, probably Thursday. All right, probably Thursday. We have some different types of contracts, and we'll go through all of them. Listing contracts, buyer's agency contracts, contracts to procure a tenant. Maybe you're working for somebody who has a property, you need to find a tenant. Property management contract, tenant representation contract. What if you're in a commercial business and your client needs a bigger space, right? You're going to represent them. That happens. Dual agency contracts. Remember, everything has to be in writing, right? It has to be informed dual agency. And then we're going to get into an employment contract or an independent contractor agreement with our broker, with our own broker. So all of these things are going to be contracts that we're going to get into, all right? Type of agency contracts. Let me ask a question. What's missing here? The sales contract isn't there, right? Are we a party to the sales contract? Do we have anything to do with the sales contract? Nope. We won't even be mentioned. We might be mentioned here or there, but our commission's not in that sales contract. Our anything has to do with how we get paid or anything else like that, a broker hold harmless, they're not in the contract. So your commissions are going to be worked out through the listing contract or the buyer's agency contract. They're going to be in both. We're going to see them in both. Okay. So in order to get paid, in order to be hired, we have to have it in writing. Written agency agreements are a must. There is no such thing as an oral agency agreement once we get to the stage for buyers where they have to present an offer. Okay, everything has to be in writing. It has to be signed by everybody, brokers included, including your license, right? Including the broker's real estate license. And these things have to have a definite start and a definite termination date. Okay, definite termination date. They are not automatically renewal. There is no automatic renewal. Okay, now we can extend, when we can do an amendment and extend it, or an addendum and extend it, right? But it does not have an automatic renewal. Property management contracts have automatic renewals. That's the only type. Property management has automatic renewals. We do not. Buying and selling real estate does not, has a definite termination date, all right? And it's going to have the non-discrimination provision, which we talked about earlier, where it says that we're going to abide by fair housing. Those are in all of them. The listing agreement, an employment agreement rather than a sales contract. It's not a sales contract. All right. It is an employment. Now, obviously it's there in big and red. Square footage is not required of the property. We do not have to measure the house. However, if we do, it has to be accurate. If we measure that house, it has to be plus or minus within 5% of what the actuality is. Anything more than that, and it becomes misrepresentation, all right, or fraud, depending. Okay, so if we're going to, the seller doesn't have to say anything about square footage, you don't have to say anything about square footage, but if either one of you says something about it, documents it, it has to be within plus or minus 5%. Okay. So if the seller does not initially give dual agency permission, they can later orally authorize it as long as it's reduced to writing before the first offer is submitted. So you can call them up, but then you better bring them a document, all right, so they can sign off on it. Both the listing agreement and the buyer's agency agreement are going to specify compensation, all right, duties owed by the agent to the seller. What does the agent owe the seller? And then what does the seller do for the agent, right? What does the seller do for the agent? So compensation, how they're going to get paid, how we're going to get paid is never in the sales contract. It is always in the listing agreement. Always in the listing agreement. All right. And we are due their commission when we produce a ready, willing, and able buyer whose terms acceptable to the seller. Terms acceptable to the seller. Mm-hmm. And our firm can set compensation rates. Okay. They can set compensation rates. So you're going to go and you're going to go to a pre-listing meeting. And you are going to go out there and you're going to talk to them about the agency brochure. It's the first thing you're going to give them, right? Tell them what your company policies are, right? Make sure that they don't give you any information, any confidential information if they don't hire you, right? It's not the easiest thing in the world to do. I get it, but you got to try, right? You have to do your job. You want to walk around the house. You want to see what's there. You want to see what are any significant defects, significant features, who's what's staying, what's not, what's personal property, what's fixtures. We talked about those a while ago, right? Maybe we need some repairs, improvements, staging. Make sure that the listing data is accurate and complete. That's going to be really important. Let me go back here. What I want to do is want to know when I walk into first, who the decision maker is. Well, isn't that the husband and wife who's sitting there, or the husband or the wife or whomever? No, not necessarily. What if they're selling the house that grandma's lived in for the last 50 years? The husband and wife happen to be the owner, but grandma's lived in it for 50 years and you're working hard. I want to know what? How's grandma feel about this? Right? Does grandma have the power to stop that sale after you found a ready, willing, and able buyer? Or after you offered a contract? All of a sudden, grandma is not moving. She got her heels dug in. Said, nope, sorry, we're not doing that. No way. No way, Jose. We ain't doing it. Or, worse yet, you're walking around the house. They're showing you around. Who lives here? Yeah, we have our kids here. How do they feel about it? Yeah, they're fine. They're looking forward to going back home, back up north to where grandma is and all of that. I say, really? Okay. We walk around the house. I look into the kids' rooms. Beautiful house, nice rooms. The young lady who is a sophomore in high school, junior in high school, she's got all kinds of trophies and things in her room, and she's on the cheerleading squad. She plays softball with her high school, and she's on all kinds of different things and everything else. And I walk and we go walk around, and I say, all right, for the gals in the class, put yourself as a 15-year-old junior in high school. And I'm going to tell you that you're going to move from North Carolina in beautiful weather, and you're participating in all of these things. And I'm going to move you up to Buffalo, New York, because that's where grandma lives. Who's the decision maker now in my house? And that's where you go around and you look and you pick up clues, your red flags, right? Mm-hmm. So you're looking at this, and now you want to ask mom and dad, is she going to go? And 9 times out of 10, they're going to say, yeah, she's ready to go. And I'm going to say, yeah, this one, I'm going to lose this one. I'm going to lose this one. So that, because she ain't going nowhere. Now, you all were there. All of you were at one particular time, with the exception of the guys, obviously. You were all 15 and 16-year-old gals. You all know that you weren't leaving high school to start all over again. Not if you were a junior. There ain't no way. I don't care what dad's got. Dad better give up his job or go find an apartment where he's got to go, because we ain't leaving. We ain't going nowhere. So even if they say they are, you need to pick up those clues, because you better be darn sure, because it costs you money to market that house. It costs you time. It costs you a lot of things that you might have to do to fix that house up, right? Trying to sell that house. And then when you get an offer, what's going to happen? We can't do this to our baby. We can't. I can't take her out of school. I'm sorry, Sam. I'm sorry you made all of that effort and you spent all of that money, but we simply can't. Do I have any recourse? I don't have any recourse. I'm out. So you got to look for those things, right? Because they're the real decision makers. So that's one of the things you're going to do when you first go there. You always you could have been in a development and seen houses in that development 100 times. On the 101st time, you're still going to ask them to show you around the house. It's unique. Each one of these pieces of property is unique. Maybe they have some different decorating ideas. Maybe they have some things they need to work through. While you're doing it, you can look about construction, alterations, any repairs. Do you have the permits for that new deck? Do you put a bedroom on upstairs? Do you have the permits? Is that all permitted space? You want to find that out, because that's a material fact, right? What about septic systems, right? Are you on septic? If you're on city water and city sewer, it's not a problem. But if you're on your on-site septic system, that's a problem. What kind of capacity do you have, right? Those are things that you got to ask, okay? What are we going to do? What are we going to charge? Those are 2 things they were going to want, right? Those are 2 things they're going to want to know. How much mortgage do they have? Can they sell the house and pay off their mortgage and pay your commission? Can they do that? Are we going to be in a short sale, right? Do we have to go to the bank and ask for a concession? I hope we don't, but again, that's something those are material facts. How much space do they have? How much room do they have in the yard? What's on the seller's deed? What's on the survey? You want to be checking all these things, right? And again, if you're going to report building square footage, it has to be accurate. Okay, it has to be accurate. Brings us to the types of listing agreements. There are 3 types of listing agreements, of which 2 you will never see in your career. I'm taking a bold step, but I have been doing real estate down here since 2009. I have never seen one of these, and I've only seen others, and I think they only because they grabbed the wrong form. So we have open listings, we have exclusive agency listings, and we have exclusive right to sell listings, okay? Exclusive right to sell. So, and then we'll talk about limited service and protection agreements as we go through this. An open listing is any place that has contracts with multiple brokers to sell a single piece of property. And the brokerage that brings the buyer is the one that gets paid and the rest don't. This is an open listing. Now, whoever sells it gets paid. However, If the seller finds the buyer himself doesn't pay anybody. He doesn't pay anybody. Okay. This is an open listing. Now, I've never seen one of these. So they're still legal and they're still available, but we have a multiple listing system. Don't we have every agent that's out there being able to see your property to bring the buyer? So we don't really need an open listing, right? One person puts it in the multiple listing system puts it out to all the agents and everybody sees it. So everybody's trying to sell it, right? So if we have an owner, we have a buyer, get it. So we don't see this much. Open listings are, I doubt you're ever going to see it. But know they're there because this is a problem topic and you're going to get asked about these three. All right. So open listings, multiple agents, only the person bringing the buyer gets paid, and the seller has the right to sell without paying. If they're independent, they're without paying. Okay. Now, the second one that I doubt you're going to see in your career is an exclusive agency listing. An exclusive agency listing. And that means there's just one agent in an exclusive agency listing. And the broker receives a commission if the broker is a procuring cause, right? Somebody brings it. But the seller retains the right to sell without obligation. So they can still sell it as a for sale by owner, but if you bring the buyer, they'll pay you. Not very helpful to us. I'll be out there marketing and spending my money on advertisement and everything else, and somebody come and knock on the seller's door and say, hey, I want to buy your house. The seller says, fantastic, come on in. He says he sold the house to the buyer, but the buyer saw all this stuff from what? My advertisement. I can't stop that. This is one, like I said, I saw one contract probably back in 2010, and I think they grabbed the wrong form. But that is an exclusive agency listing. Okay, exclusive agency listing. One agent, if the agent brings the buyer, the agent gets paid. If another broker brings the buyer, the agent gets paid. If the seller sells it by himself without the agent, he doesn't get paid. All right, does not get paid. That's an exclusive agency. Now, the one you're going to see 9,999 times out of 10,000 is going to be the exclusive right to sell listing. Exclusive right to sell listing. And this is going to be our most common. All right. You have one agent, one company. And regardless of who finds the buyer, we're going to get paid. The seller finds it themselves, we're going to get paid. Another broker brings the buyer, we're going to get paid. Okay. This is the one that has the most protection for us as brokers. And this is the one that's going to get us paid. Okay. This is the one we're going to use virtually every time. I doubt that you'll even be able to find the open listing and the exclusive agency listing. They're not illegal and they're perfectly available, just not used. Okay, just not used. So those are the three. You have open listing, multiple agents, seller cannot pay anybody. You're only going to pay the person who brings the buyer. Exclusive agency means that there's only one broker, but if the seller sells it by himself, he doesn't pay anybody. All right. And then the third one is an exclusive right to sell, which is the one we're going to use. And if regardless of how we find the buyer, we're going to get paid. That's the one we're going to use. Okay. All right. So this chart gets confusing. So please, if you want to look at it, that's fine. Now, there is also something called a limited services listing agreement. In a lot of cases, not a lot of cases, but in some cases, they're going to do a menu type listing. So maybe I got somebody who doesn't want to pay a full commission, but they just want certain things from me. like put it in a multiple listing, put a sign in the yard, put a lockbox on the door, and maybe when I get the contract, you help me fill it out. And that's about it. So I charge them for each one of those things. And that's how I get paid. Okay. I charge them X amount of dollars for putting the MLS, X amount of dollars for negotiating the contract, X amount of dollars for the. That's a limited services listing agreements. Now I still have to abide by the law. I still have a fiduciary relationship with these people, right? But I'm only going to do certain things, okay? Now, the problem is if you've got the buyer's agent, you're probably going to have to negotiate with the seller directly, right? Or you're going to negotiate with a seller's agent that's going to be very difficult to find because they're out doing something else. They're not really, they got paid for all of this stuff already. So those are things that you might work against. So a limited services listing agreement basically is a menu type a la carte fashion. Pick what you want and pay me for those. We have a price tag on those, and then you're on your own. Okay. We see it once in a while. It's not unusual, but it's not the preferred method really. So the listing contract, what does this look like? Let's go through it. Let's take a look at it, all right? Instead of going through all of these things, we'll just take a look at how much we can go through. This is an exclusive right to sell listing agreement, okay? Now notice up here, it's 13 pages long. It's quite the document, all right? So we probably won't get through all of it. I'm gonna skim it, but just to give you the highlights, all right? I gave you copies of this. You should probably read it, okay? Understand what's in here. This is an exclusive right to sell listing agreement, Form 101. Now, also, when you're looking at these forms, please pay attention to the lower right-hand corner of each page. This gives you the revised dates and the most accurate, okay? So this Form 101 was revised in July of 2022. It is the most recent form. So if you have one from 1999 or 2019, throw it out, okay? Use the most recent forms. That's going to be really important, all right? On every form that we have, on the bottom right-hand corner is the date that it was last revised. Please use the most current one, all right? All right. So we want to know who the seller is. Now, the seller is the person or persons on the deed. So if we have 5 people selling this, we got to get 5 names on this, and all of them have to sign. Now, we have an addendum that would add an additional signatures page to this, all right? That's out there. There are 14 or 15 different addendums that we'll see. All right, so we need to get everybody to agree. We can't just have one person. Now, if it's an LLC or if it's a corporation, the person signing this has to have signature authority. So they have to have some sort of document that says that they are the attorney in fact for the corporation. They have signature authority to sign to sell this, all right? So they have to have that. All right, notice that, so their names would go here. Notice that this is the listing firm they are hiring, okay? And it goes there. Second paragraph of this note, if the owner of the property is a corporation, limited liability company, trust, or other legal entity, the entity should be named as the seller, and a duly authorized officer, manager, trustee, or other legal representative of the entity should sign this agreement on the entity's behalf. All right. All right. And again, there's a lot of other things, but for the sake of time, big bold letters right in the middle of the first page. Seller represents that as of the effective date, the seller is not or will not be, if the property is currently listed, a party to the listing agreement with any other real estate firm regarding the property. We're not working with anybody else. Rule number 1. Second sentence says, the seller also represents that the seller has received a copy of the Working with Real Estate Agents disclosure and has reviewed the form. All right, so we're going to ask them straight up. Have they gotten this? All right, have they gotten this? And we want to make sure this is what we talked about earlier, right? How long is this going to be, right? Effective date was the day we have the last communication, last signatures, initials, and it's going to end on its expiration date. All right. So the agreement shall become effective, and the seller and firm's respective rights and obligations shall commence on either the effective date, all right, or if the cut. Now, this is where I talked to earlier about if their client calls me up, right? It was Anastasia's client. I think I used her for an example. They called me up and said they want to change agents. Well, this is where I can go ahead and do this listing contract, but I can do it right here. And it says the property is currently listed for a sale exclusively with another real estate firm. The seller represents that the current listing agreement expires on this date. The effective date of this agreement shall commence immediately upon the expiration of the current listing agreement. So it's okay. I can go ahead and get into that, even though he might have a month left on Anastasia's listing. I can go ahead and do that. All right. And then our expiration date. All right. And that is a hard date. Property addresses. Okay. City, street, county. All right. But remember, we talked about legal descriptions. Here they are: plat, lot, block, section number, subdivision, right? Plat book page, right? PIN, other identification. If it's in your county's records, it should go in here. Okay? If it's in your county's records, it should go in here. Street address, all these other things. Okay. We don't have to worry about that note. You can read the note on your own. Number 3 is fixtures. Now, remember we talked in chapter 2 about fixtures, and we argue about what's got to stay and what's not, and you know what, all of the IRMA taxonomy and all of those things. Well, what they do in both the listing agreement and the contract is they put in here the normal things that would be considered a fixture. All these things when you talk about it. Security systems, stoves, antennas, basketball, solar electric, all of these things are normal fixtures, all right? But if we are going to take them out, if we're going to take something out, we need to put it down here. So we have the opportunity to take it out, all right? We have that opportunity to take it out. We would put it in here. Is there any personal property, right, that's going to transfer to the buyer at no value? We would put it here. Maybe you're selling a condo on the beachfront and the furniture is going to transfer at all no value. That's usually what happens. It's customary to transfer the furniture for those kind of things. All right, you would put that here. Are we going to give them a home warranty, right? How much and with whom? That's what we want to know. Are we offering that as an incentive? What's going to be our listing price, right? And how do we want, what kind of terms? Price and terms, right here. Now, number 7 is going to be important. This is the firm's compensation. How much are they going to pay us? All right. What's our fee? What percentage of the gross sales price? Or are we working for a flat fee, which shall include the amount of the compensation paid by the firm? All right. The fees earned if we produce a ready, willing, and able buyer that's procured by the firm, real estate firm, or anyone else during the term. If the property is sold, optioned, exchanged, conveyed, or transferred, or the seller agrees during this term of agreement, all right, to sell, option, exchange, convey the property at any price upon any terms whatsoever. All right, we got all of that. Now, this protection period, we have to understand this. Every person you've ever met in your entire lifetime has always been fair and honest and would never think of cutting you out of a commission with that. It's just life, right? That we're all human beings and we're all going to hold hands and sing Kumbaya and we're all going to make a lot of money and that's all going to be cool, right? Yeah, no, doesn't work that way. So number 3 says, if the circumstances set out in 1 or 2 above have not occurred, and if within X amount of days, now that's up to your company policy. This could be 90 days, it could be 120 days, it could be 180 days. But just for our class example, and please understand, this is class example only, let's use 90 days, all right? So if within 90 days after the expiration date, the protection period, the seller either directly or indirectly sells, options, exchanges, conveys, or transfers, or agrees to sell, option, exchange, convey, or transfer the property upon any terms whatsoever to any person with whom the seller firm or any cooperating real estate firm communicated regarding the property during the terms of this agreement, or any renewal hereof, provided the names of such persons are delivered or postmarked to the seller within 15 days of the expiration. However, the seller is not obligated to pay the fee if the valid listing agreement is entered into between the seller and another broker. This expires on January 4th. Let's say, using our example from before, Anastasia, her listing expires the 4th. I take it over on the 5th. If one of the buyers come back on the 5th and they said that they were looking at this house previously and I commence the sale, then the last broker is out. They don't have this protection period. However, let's just assume that her contract expired and nobody picked up the listing. And a buyer that was introduced during that relationship prior comes back after the contract is over, after the listing contract is over, and they say, we'll buy it. Well, why don't you just take the price down a little bit? You won't have to pay the commission. If it's still within that 90 days or 120 days or 180 days, Anastasia gets a commission. She's entitled to it even afterwards because she was the procuring cause for the buyer. Okay. The hard part about this is that you don't find out until a long time later because it'll be dumb luck because she's moved on. She's doing other work now, right? So she would have to find out through the grapevine somewhere in that particular case. So this protects you. This is the protection period for the broker. It stops you from getting fired and then the seller going back and picking up a buyer that was there before, or making a deal with a buyer that says, wait 3 or 4 days until my contract expires and I'll take 3 or 4% off of the price. It happens. It happens a lot, but you're protected in the listing. All right. Let's see what else. Now, number 7 tells us that we're going to get paid and how we're going to get paid. Number 8 says that we're going to cooperate with other brokers, other firms. I want XYZ company to bring a buyer. I'm going to have to offer them something. All right. So we can either cooperate with sub-agents representing the seller and offer them the following. Cooperate with buyer's agents representing the buyer and offer them the following, whatever we want to do here. All right. So that's how we're going to pay other agents. Number 9 gives us the duties. What are we doing? What are we doing? So we're going to make our best efforts to find a buyer. That makes sense, right? We're going to disclose the material terms of the offer. We're going to disclose material facts, which we've already talked about. Other professional services. We're telling the seller right now that you need to get an attorney, you need to get a contractor, you need to get an appraiser, you need to, if you want, we don't do that. We're not qualified people to do that. If you need those things done, you need to go find them and hire them separately. So in that other professional services, they need to go hire professionals, not us. We're not to be relied on for that information. And that's what other professional services do. Providing agreement to a listing service. We're going to put this in the multiple listing system, MLS, get some coverage. All right. This is our discrimination language or our anti-discrimination language in bold. All right. The agent firm shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, realtors have the ethical duty to conduct such activities without respect to the sexual orientation or gender identity of any party or prospective party. Okay, that all falls under the sex umbrella now, but it is there in addition. All right. There is a warning here. Buyer letters to sellers, love letters. I don't know if you've heard of them before, but if somebody really wants to buy a house, they'll write a nice letter to the owner, talk about their family, talk about how much the family wants to move there and all that other stuff. Well, what was happening was in those letters, they were kind of giving away race, color, religion, right? All of those things. So the seller could make a decision based on any of those things. So it's very, very uncomfortable now, and they're probably frowned upon a lot more than you think. So it says buyer letters to sellers. To entice a seller to choose their offer, some buyers write personal letters to sellers expressing why they wish to purchase the seller's property. Such letters often contain personal information and reveal characteristics of the buyer, which could be used knowingly or through unconscious bias as a basis for the seller's decision to accept or reject an offer that may violate state and federal fair housing laws, or used to form a basis for a claim that the seller, possibly the seller's agent, have violated fair housing laws. In order to avoid potential liability for unlawful discrimination, as well as the appearance of impropriety, seller should discuss with the firm how any such letters may be submitted will be handled. Okay. Best thing to do is send them back to the buyer's agents and do not accept them. All right. Or write in the listing, please do not send us those. Okay. And we want some initials from the seller here. We're gonna market this. When are we gonna start the marketing? The day we start getting the effective date, right? Are they gonna allow us to do public marketing? Are they gonna allow us to do coming soon advertising, place signs on the property, do open houses, advertising other than on the internet, right? Are they gonna allow us to do internet advertising? So we gotta get check marks for all of these, okay, so that we can do that. We could have this as an office exclusive, which means that the only people can buy or sell this house are going to be in my office, and I can't advertise, right? So if they want that, this is called a pocket listing. They're frowned upon. You're not using the MLS, and it's really, you're going to get a lot of people mad at you if you don't make it available. So maybe you're not getting the best representation there, okay? So that's something that you may want to talk about. Lock boxes and keys, do they want one? Maybe, maybe not. We need authorization. All right. All right. This is a hold harmless. It says that we're not, if somebody unauthorized use of the key or lockbox, they're not going to be, we don't have control of that. All right. Any visitors during an open house, this is basically, they can't sue us if somebody in the open house rips them off. Anybody want to take a guess? The number one thing missing after open houses? Prescription medicines. They're left out on the counter, they disappear. So make sure that your client puts everything away. And I'm not talking about just put them in a box that right as you open up the closet door, you can see them in the box. Put them away, right? Lock them up, do something with them, all right? But that is one of that's probably the most that gets missing right away. Prescription meds, not a good thing. Yeah, so seller agrees the seller is solely responsible for securing all valuables, medications, tools, other items of personal property during the terms. Big warning here, and we need to know this. It may be a crime under federal and state laws to listen to or record an oral communication through the use of electronic, mechanical, or other device without the consent of a party to that communication. If there is a video audio surveillance device on the property, the seller is advised that no audio surveillance device may be turned on during any showings, open houses, investigation, examinations, or inspections of the property. And two, that the placement of any video surveillance device should not violate a visitor's reasonable expectation of privacy. So don't put video cameras in the bathroom, rule number one. And number two is that you cannot use audio in the law as a course of law. You can use video, but no language, no audio. So you have to shut all those things off. Now, how you're going to get Alexa to stop listening, I don't know how you're going to do that. But Alexa hears everything, right? She wouldn't be listening if she was. She wouldn't be doing her job if she wasn't. So she hears everything, but you cannot use that against the property. All right, you cannot use that. Earnest money, what we're going to do, we're going to hold it in a trust account, right? And then seller representation. Who's the seller? How long have they owned it? Are they going into bankruptcy? Access, all right? Is it a mobile home, manufactured home? All of this stuff. It's right here. All right. All right. So you can read the rest of this. You can read the last 5 pages and know what else is out there. And I would, all right, special assessments, fuel tanks, all right? Particularly pay attention to the notes and the warnings, the blues and the reds, all right? Down on the bottom of the last part of this, all right, we're going to talk about, there is a big red warning about wire fraud. Oh, there it is. Wire fraud. Wire fraud is a very, very dangerous thing. And when a buyer is wiring money, if they wire it to a fraudulent account, it's gone. It's gone. There's no recourse. Now, I know 2 examples, one for $256,000 that was found very luckily because it was going from a Wells account to a Wells account, but it was fraudulent. They found it. And the other one was for about $850,000 out of Texas that somebody was wiring money to a closing as their deposit, $850,000. Allow you to catch your breath, and it was gone, disappeared, because they wired it to a fraudulent account. So please read this and please take heed. Okay, this is extremely important stuff.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.